A title, Consent and Other Common Defenses. A disclaimer. The opinions, findings, conclusions, and recommendations expressed in this program are those of the speakers and do not necessarily reflect the views of the U.S. Department of Justice. This project was supported by the U.S. Department of Justice's Elder Justice Initiative and the Office on Violence Against Women. Portions of this program are protected by copyright. If you would like to copy, display in a public setting, adapt, or distribute this program, please contact elder.justice@usdoj.gov. Paige Ulrey, Senior Deputy Prosecuting Attorney, Seattle, Washington.
The issue of capacity ends up coming up so often for us in almost every form of abuse that we prosecute. So the reason it comes up is because the most common defense that we see to these crimes is consent. So we see consent being raised in financial exploitation cases where the perpetrator says the victim wanted me to have their money. We see it coming up in neglect cases where the perpetrator says the victim didn't want medical care and I was just following their wishes. We see it coming up in sexual abuse cases where the perpetrator claims the victim wanted to have sexual contact with them. So the question often becomes for us, did that victim have capacity to consent to that transaction that's at issue? Or was the victim's capacity impaired to the extent that they weren't really able to understand what was going on, or that they weren't able to have very good judgment about that decision?
The interviewer.
What kinds of defenses are common in these cases, and are you able to anticipate them in the course of evaluating a case?
Liz Lowy, former Chief of Elder Abuse Unit, Manhattan District Attorney's Office, New York, New York.
There are many defenses that I think a prosecutor will just be able to anticipate right away. Maybe the most common one on exploitation cases is the whole, this is my mom, or this is my grandma, or this is my dad. And I think there's a common misconception amongst exploiters that if it's family, it's somehow different than a stranger case. And having run a domestic violence unit, I can honestly say we're where we were about 20 years ago on that many people on the street don't understand, that if it's family, it's not somehow different. It's not, a different case than if a stranger steals a lot of money from you. So family members are charged, even if a victim is 95 years old and suffers from dementia, and the son or the daughter is the sole beneficiary in the will, there can be a criminal case. So that's a common misconception and a common challenge, and it comes up as a defense. Another common defense is, there may be some impairment, there may be some dementia, but it's mild, and there were lucid intervals. And you don't realize that a few weeks ago, she told me that I could have X, Y, or Z. And we encounter that a lot, and those are tough cases tough defenses to prepare for. But basically, you have to do your research. You may have a victim who has some dementia, but can say, I didn't gift it on that day, and who is consistent on that, and can be backed up by a doctor. You may actually have a question about whether there were lucid intervals and not be able to go forward on your case. Or you may be able to show that the victim was really pretty bad during that time period, that there were lucid intervals, but not during that time period, and you can prove your case that way.
Paul Greenwood, Deputy District Attorney, San Diego, California.
I always evaluate a case to think, okay, if I was defending this case, what would be my closing argument? What is my defense on behalf of my client? And typically, the defense is going to be, but she wanted me to have it. Or I was only borrowing it, because ultimately I have to prove that this defendant took this asset belonging to the victim with intent to permanently deprive without the victim's consent. So that's what I focus on, is how do I overcome, how do I rebut any suggestion that the victim either consented or was lending it to the suspect for an amount of time. And sometimes the evidence needs to be bolstered. So not every financial elder abuse case that I get in can be issued. I sometimes have to send it back, I have to reject it conditionally, and say to the detectives, you know, I need this done, I need this person interviewed. We need to really tackle head on this consent issue. Let's go talk to victim's doctor and really try to overcome those classic defenses.
Tara Patet, Prosecutor, City Attorney's Office, St. Paul, Minnesota.
Another thing that is often presented is self-defense. Sometimes they'll say an older adult, when they develop dementia, might become combative or hard to handle because due to their dementia, and the person will say that, well, I was acting in self-defense. Often we'll have perpetrators who say that the injuries were accidental, that if they're caring for a loved one, maybe they will say, I was trying to pick her up or maybe help her to the bathroom and she fell and that's what caused the bruise that is showing up that was previously reported as abuse. In those cases, really, it's just important for the prosecutor to really analyze the evidence and scrutinize the explanation that is given in light of the evidence that you have in the case. And very often, those two things won't necessarily match up. So if someone has said that an injury was caused, say, by hitting it on their leg on a table, then you might take a look at how high the table is and where the injury appears on their leg, just in a very simple example.
Arlene Markarian, Chief Elder Abuse Unit / Domestic Violence Bureau, Kings County District Attorney's Office, Brooklyn, New York.
The most common offender of elder abuse nationally, the profile is going to be the adult child or grandchild or other family member of the victim who is either drug addicted and or mentally ill. So they have some degree of mental illness, they're self-medicating with alcohol or drugs, they're unemployed, they're living with the aging parent or grandparent, and they need money, and they take money from the aging parent or grandparent or other relative. So what happens in a lot of these cases is either the defense is going to be some sort of psychiatric defense because there is a psychiatric issue, perhaps an intoxication defense because they're saying they were very high or drunk at the time of the incident, or many defendants will start off by saying, even as early as the arraignment, the first time a defendant sees a judge, they will claim that their mother, their father, the victim has dementia, they're crazy, and this never happened. Or their mother or father fell because they're old and they always fall. And so these are the usual defenses in these cases. I want to anticipate as many defenses as possible, so I'm not surprised at trial. The worst thing that can happen is you're surprised and then you weren't ready to deal with it. So you think of every possibility, as absurd as it may be, even self-defense where the victim is 90 years old and in a wheelchair. It may sound crazy, but defendants will claim self-defense. They'll say she's crazy, she's got dementia, she came at me, and I was defending myself. And then some people will say, oh, who's going to believe that? Well, somebody could. You just need one juror to believe it. And if you don't provide the right evidence to combat that defense, you're giving them the out to believe that. So what I'll be looking at is, for example, if it's intoxication, I want to know if this person is just a chronic drunk and how much alcohol did they have in their system and were they able to walk up and down the stairs by themselves and get into the police car by themselves. This is typical in an intoxication defense, whether you're high or you're drunk. If you're saying that you couldn't form the intent because you were so high and so drunk, there is a charge like that in New York State. So you would bring out those details. Well, wait a minute, you were able to get in the car on your own. You were able to walk into the jail cell without falling down and stumbling. Things like that. Same thing with self-defense. Where are the injuries? Does he or she, the defendant, have any injuries? The size differential, things like that you would want to get ready for and bring out in your direct examination.
In an in-home neglect case, the most common defense that we see raised is that this is what the victim wanted, that the victim didn't want medical care, and it was really hard for me as her caregiver, but I was just following her wishes. And in those cases, it really is important for us to look at what the victim's capacity was, whether or not she even had capacity to refuse medical care, and also then what her or his medical history was. Were they people who always went to doctors and always had surgeries when needed and really sought out medical care? Or are these truly people who never wanted medical care? And in most cases, most people do accept medical care and seek medical care, so usually it's not a viable defense. But it can be one that's hard for us to defeat because we're dealing usually with people who are in a very isolated situation. So we don't usually have many witnesses besides the defendant. And in most of the neglect cases that we file, the victim is dead. The other thing that we see that comes up more often in facility situations is the defense that the victim was dying anyway. And that really, even though the care might not have been great that the victim got, it was not what actually caused his or her death. So again, we need medical experts to help us with that.
Logos appear. NCAL, www.ncall.us. Terra Nova Films, terranova.org. Funded by the U.S. Department of Justice Elder Abuse Initiative and the Office on Violence Against Women, www.justice.gov/elderjustice.